Good morning, everyone, and welcome to the committee's 33rd meeting in 2019. Could I please remind everyone to make sure their mobile phones are on silent? The first agenda item is the Agriculture Retained EU Law and Data Scotland Bill. And I'd like to, before we go into that agenda item, invite members to declare any interest that they have. I would like to declare that I have an interest in a farming partnership. Peter.
Convener, I would also like to declare an interest as a partner in the farming business in the North East.
And Stuart.
I have a very small registered agricultural holding from which I derive no income.
Thank you. This is our second evidence session on this bill, and today we're going to take evidence from data and research organisations. I'd like to welcome the panel, Maureen Faulkner, the Regional Manager, Scotland for the Information Commissioner's Office, Stephen Thompson, the Senior Agricultural Economist and Policy Advisor to Scotland's Rural Colleges, Professor Julie Fitzpatrick, the CEO of Morden Foundation and Scientific Director, Morden Research Institute, and Ellen Wilson, the Chair of the Scottish Biodiversity Information Forum. Now, questions. The first question this morning is going to come from John Finney. John.
Thank you, Convener. Good morning, panel. There's quite a number of questions coming up, as ever. I wonder just, though, to start off, if you could maybe give your initial reflections on the bill and indeed whether it meets any expectations, aspirations you may have had about how we go forward from here, please.
Julie, off you go.
Thank you. I thought the bill read very well indeed, I have to say, and I think the relevant, the retained EU law is in general highly relevant to the Scottish position. I think the objectives of the Common Agricultural Policy meet well the needs of Scotland as defined many years ago when the CAP was set up. The 2 acts on rural development and the 3 acts on direct payments and other aspects, again, I think broadly fit with what Scotland is generally going to require, but also it's important that we have the ability to make regional and national decisions about how the CAP reform is likely to be. So I think it's well described in the bill. In terms of the data, I felt that it's correctly focused around the agri-food chain aspects of agriculture, and that the regulation to compel the supply of data and the handling and processing of data is appropriate. Again, there's different categories of data requirements, and again, I thought those were all-encompassing and covered many of the different areas of data requirement. I won't say so much about the data regulation and processing because that's not my area of expertise. I thought the reasons for the data were clear and appropriate. And under the general section, I again like the idea of the power to operate CAP regulation beyond 2020. So my comments are generally positive about the bill from a data processing and a data information perspective.
Okay, thank you.
John, do you want to work down the entire
yes,
panel?
If other panel members have a general comment, that would be appreciated. As I say, there's quite a number of specific questions coming, but your initial thoughts on the legislation, please. Steve.
So it's welcome that we've got a bill in situ, simply because we need it if we're going to take agriculture forward and take payments beyond 2020. The life of the current CAP ends in 2020, the end of 2020, as most people know. So we need provision to be able to either maintain the existing regulations or actually amend the existing regulations as Scottish ministers and the Scottish Parliament see fit. And I think that flexibility that it's bringing in is important because there's always been concerns that we're over-regulated. Some of the schemes may not be nuanced enough for the Scottish situation. And I'll have that flexibility, as Julie mentioned, to actually ensure that we're delivering policy in the right areas. Some of the issues around governance still remain. So when this whole Brexit process started, I was always concerned as to who was going to act as the Commission, the Parliament, all of the EU institutions, because they are the legislator at this stage, of which the member states have to apply to them for permission to make changes. And I think that it's important that we still have that check and balance situation in place. Quite a lot of it goes through the affirmative process, which is good. And ministers need flexibility to make amendments where they're minor amendments and not changing the nature of the legislation. On the data side of things, I think this is a welcome update in terms of it explains explicitly why data is being collected and for what purposes, and it will enable the government to share data with institutes like ourselves to help them analyse data to better understand how policy is performing and how the sector is performing. So I think the provisions are pretty welcome.
Thank you.
Maureen, do you want to?
I suppose everyone's looking to the ICO in respect of, can we do this?
Just to clarify, you don't need to touch anything.
Yeah.
It all happens. And I should have said at the beginning that if a question's not directed at you, just indicate and I'll bring you in. And if you all look away at the wrong moment because no one wants to answer it, there will be one member of the panel that will get nominated. Sorry, Maureen.
No, that's okay. Under Article 36(4) of the General Data Protection Regulation, policymakers, where there's going to be draft legislation proposed that has a processing of personal information element to it, they are required to consult with the ICO. And Scottish Government did that. They came and they consulted with us at the appropriate time. As regards the content of the draft legislation as it was, the only issue that I wanted to engage with the government on was the issue of relying on consent for research purposes. And that wasn't because we were going to be telling them that they couldn't do it. It was that, well, as a matter of fact, it was to suggest that they shouldn't be relying on consent because the kind of research that was going to be done, which is this notion of gathering information so that you can better determine policy in the future, it is in the legitimate interests of the policymakers. So consent from a research perspective is very, very difficult because it skews results, and therefore legitimate interest is the more appropriate legal basis to be relying on. So from the regulatory perspective, from the ICO's perspective, we had absolutely no issues with what was being proposed in the bill at that time. It's changed slightly. I still have absolutely no issues. And to be perfectly honest, I was saying to my colleagues earlier, I was actually going to send an email to say, I really don't think you need me to come along and speak to you, and this is why. But the email got so convoluted, I thought, as well as coming along and telling you in person why, because I appreciate that data protection is not the easiest bit of legislation to get your head around.
Okay. Ellen.
I should say I'm not any particular policy expert, so I don't normally comment on bills, but I think overall I would really welcome the opportunity that this bill provides to improve and simplify. That said, the simplification element of it does bring some concerns about whether that would allow us to still understand the impacts around biodiversity and the impacts for the Sustainable Development Goals. So that might be getting into a bit of detail, but broadly, really welcome the opportunity.
Okay, thank you very much indeed.
Stuart, you wanted to come in.
I just wanted to come back and seek clarification of what Julie Fitzpatrick said, because you used the phrase CAP meets the needs, Scotland's needs. And I think I got some support in what Stephen Thompson said in relation to the support regime, but perhaps less fulsome support in relation to regulation. And I wonder, thinking of things about the regulations in relation to something like the three-crop rule, which just was a Mediterranean issue that did not suit Scotland for a single second, whether you might want to say that you were talking about support functions rather than regulations, or if you disagree with me, tell me otherwise.
I was mentioning support functions, but then some of those come from the regulations, and I think that link is important. And I'm not a lawyer, but reading the bill and the supporting notes surrounding it, I felt that the proposal as written, does cover that link. So it does give the regulations that would allow the interpretation of Scottish-specific payments or other regulatory issues to be covered under this bill. So it's less on the regulations and more on the policy.
Thank you.
Okay. The next question will come from the Deputy Convener, Maureen Watt. Maureen.
Thank you, Convener. Morning, panel. The Stability and Simplicity consultation asked for views on specific changes to be made to schemes and policies in the transition period to a new rural policy in 2024. So to what extent do you think that this legislation is fit for purpose in delivering the changes required in that transition period to 2024?
Stephen, do you want to go on that?
Oh, yeah. It's quite challenging because a consultation is a consultation, and obviously within that consultation there are hugely dispersed views and opinions were given. So I think there has to be scope for ability to amend what we're doing in terms of the policy. The concept of pilot schemes is very important. If we're going to deliver future policy, we have to actually be able to test these policies to see if they work on a small scale or a regional scale, a pilot scale. Within the bill itself, I kept hearing the words or reading the words LFA, which obviously is a piece of legislation that we haven't amended to date, and the government are looking obviously to maintain it whilst they look to potentially introduce a new areas facing natural constraint delimitation or scheme. So I think it allows you to roll over the legislation pretty straightforward. Whether or not we would want to, or Parliament or society would want us to move at a faster pace given the climate emergency and the need to perhaps start making actions quicker given the new targets that we've got with net zero. And that is something that we're going to have, that government are going to have to consider, and yourselves as a Parliament are going to have to consider. But within the bounds of what stability and simplicity is set up to achieve, I think the bill covers that. So
would you be recommending then that the 2024 date be brought forward? Or is that, does it have to be 2024?
No, I don't think it has to be. I mean, the 2024 is an arbitrary thing that the government set out in the bill that post-Brexit they were wanting to provide a degree of stability that would allow farmers and land managers some degree of certainty that would allow them to take their business forward and allow them to invest in their businesses with some degree of clarity. Obviously, if we need to move faster because of other things, other factors such as the climate emergency or the biodiversity emergency that we've equally got, then we may want to move at a faster pace and actually see if we can move the industry forward. When you speak to farmers, actually, they generally, the ones I've spoken to, think 3 years, 4 years is enough for that horizon for change. And they had the same concept of change during the CAP reforms of 2015, where people were talking about 5-year transition, and some of the farmers, again, some said, some of the farmers were wishing for a faster transition, so then they would be at a point of clarity far quicker that would allow them to make decisions.
Just before I bring you in, Peter wants to come in, and I think Ellen's probably got a view, but I'll do Peter and then come to you.
Just to follow up on what Stephen's been saying, I mean, you spoke there, Stephen, about a degree of certainty, and it's certainly the agricultural industry, farmers that I speak to are desperate for some degree of certainty. And within this bill, it says that it allows for pilot schemes, and you mentioned pilot schemes as well, but when I questioned the officials last week and you know, what ideas did they have as to what pilot schemes might look like, I got no answer. So although there's a provision in there to allow that to happen, there doesn't seem to be any idea as of now what any of the pilot schemes will look like. And I think that's a huge problem going forward for the industry. You know, the industry is desperate for some idea as to where we're headed, and really there's a a complete vacuum in there. And this bill does nothing to fill that vacuum. I would welcome your comments on that.
It doesn't address what the concepts or the construct of the pilots would be. But from my understanding, there has been discussion within government on some of these pilots. I am not party to where they're going with any of these things. I would imagine that this is part of the future policy group are considering some of these things, and of course they're meant to be making recommendations early next year or mid next year, where thereafter you could take these things forward. Until we see what those pilots look like, we can't really progress. Yeah, and that's the reality. The stability bit gives you a degree of certainty that your payments will continue as a farmer for a certain period of time. But of course, within the bill, there is also the capping element as mentioned within the consultation exercise. And the capping for some people, because currently the capping is at €600,000, and the capping in the consultation, there seemed to be a favourable mention, or in the reporting it suggested between 50 and 75,000. Now that's a huge reduction for some farmers potentially. And I've always said that you've got to be very careful when you cap, that you don't cap the wrong people, i.e. those that are linchpins in a system, an agriculture or a food system. So some of the biggest recipients are potentially some of the biggest agribusinesses that you're talking about. And if you adversely affect them, then that can have a knock-on effect into wider industries.
Wants to come in?
Yes, in terms of simplicity, I think one of the things that we could do more quickly is to ensure access of data which is available for research and analysis and synthesis to benefit many of the stakeholders. In a number of areas of data protection, it's difficult to get information. Sometimes it's relatively easy under an emergency situation, but if we had better access to some of the data held by farmers, I think that would be very beneficial and could be implemented quickly. I think that also would go some way to addressing Peter Chapman's question. I think there are many discussions at the moment about pilot schemes. For example, how we could ensure the use of data in terms of sustainable agriculture, measuring things like productivity, which we need to do, plus animal welfare and health benefits. But that data needs to be released in order to make that synthesis, to make some of the pilots interpretable. And I think there are substantial discussions about how that would fit in also with CAP payments, where some of the monies, perhaps under Pillar 2 at the moment, I know it wouldn't be called that going forward, could be used in a flexible way to give targets to some of these pilot schemes to make sure they're appropriate for wider aspects of agriculture.
Ellen, did you want to come in on that? Sorry. And then I'll come back to you, Maureen. Sorry.
Not to be on that, well, on the open data point, I think it's critical that data, actually I'd make it open by default. I think it's essential that all stakeholders can access and question and analyse and play with the information from the farmer and his neighbours all the way through to government and NGOs. So I think it's absolutely essential that policy lets us in that area.
So what's hindering that sharing of data at the moment? Is it GDPR or is it... Or what is it?
For understanding of GDPR, it's probably used in defence when it could be used in opportunity. So it shouldn't be preventing or inhibiting those data being used for appropriate purposes. For example, looking at the environmental impact is a recognised purpose, but it gets in the way. So it's very, very difficult to acquire data fast or indeed openly or with the fair presumptions.
There's also another issue about some data being collected for specific purposes, and if you then want to use the data for another, perhaps aligned or different purpose, then you need to go back to get permission to indeed use that same data for a different cause. And that's certainly across the animal health sector, and I would imagine wider afield.
Maureen, you wanted to come in. Can I just ask, could somebody wrap up in there as well whether there's any commerciality involved that needs to be considered in data collection between neighbouring farmers? I'll just pick that up. Maureen, maybe you could...
I can't speak about the commerciality aspect of it, but just to flow on from what's been said about the use of data and big data, I would bring to the committee's attention the preamble that is set out in GDPR, and indeed was also the preamble of the what was the 95 directive from whence we had our previous regime. And it talks about data protection, that's the purpose of GDPR, but the bit that people forget is it also talks about and the free movement of those data. So it does talk about personal data, it talks about protecting it, but one of the big purposes behind data protection legislation is also to allow the free movement of that data. And as I say, people very often get caught up in the first part, the protection part of it, and forget about the second part. Also within GDPR itself, people again look at the articles and they don't look at the recitals. And we're very fortunate in having the recitals within that piece of legislation because it provides us with the spirit of the law as well as the letter of the law in the articles. And Recital 4 talks about personal data should be used to serve mankind. That's what it actually says in GDPR. Again, people don't realise that the whole point of data protection is to provide a framework for the safe and secure use, and that includes data sharing, of personal information. It's not set up to be obstructive, it's set up to provide a good framework for that use of personal information. And I mean, the ICO has for many, many years now been trying to encourage the use of open data, to have that data freely available for people to be able to use. It's absolutely within the legitimate interests of a government making policy decisions to try to gather as much data as they can so they can create evidence-based policy. That's what people want. And so it's from a data protection perspective, from my perspective, and I know it's easy for me, it's not an issue. But it absolutely is an issue for individuals who get caught up in it. Stephen was telling me about issues that he's had recently, and it's a lack of understanding. It's part of the myths that surround data protection, a bit like health and safety legislation. And if people could only realise that it is an enabler rather than an obstacle, then I think you would find data sharing would be so much easier.
Richard, you wanted to come in.
To come back to the point that Stephen Thompson made, would you not agree that if you have a vacuum in the UK government, how can the Scottish government know what to do, or the Bill team know what to do, if they're not getting told how much money they're getting, what system's going to be used? But that's the point. If you've got a vacuum, how can you make up a plan?
Ellen, without being overtly political in your answer.
I'd like to come back actually to John Finney's original point, if I may, to the question that
he
originally asked. So you asked about, is the legislation fit for purpose, I think, in terms of its transition now. So I'm not so able to comment on the detail of the legislation, but just coming to it with a fresh pair of eyes from biodiversity data angle. If you're familiar with the International Panel's report, Global Report on Biodiversity and Ecosystems Services that's been out recently, that makes it very clear that without a transformative change in these types of policies, there is no policy scenario under which we'll reverse the declines in biodiversity. So this bill at the moment for me isn't writ large around that. It doesn't really reflect the contribution of this particular sector to those biodiversity declines, and it doesn't really bring to life the opportunities to actually respond to those. I think more could go further there for that purpose.
I'm briefly going to bring in Emma, and then we're going to move on to the next question. Emma, you had a supplement.
Yeah, it is a question specific about data. Thank you, Convener. We've been trying to find out how many dairy farm workers are from European countries, because across my region and in the northeast, I suppose, there's many dairy farm workers from EU countries, but we're not able to find out specifically from which country and where they are working, because that is directly related to Brexit as far as freedom of movement of people in the future. So we can't make policy in the future if we don't have that data in the first place. So it's not that people are asking for the names and the addresses and the ages of the European workers. It's just basically figures so that we can plan in the future for the for policies moving forward. So is that something that is misunderstood, or how do we get that data?
And just bear in mind when you're answering this that farmers will be listening to know how many pages that they'll be completing on the survey report. Maureen. At the moment, I mean, it is a genuine question in the sense there's a lot of data collected. It's how to use the correct data. So, Maureen.
From what you're saying, you're talking about aggregate data, anonymised data. It's not personal data. So from, you know, a data protection perspective, it doesn't kick in. And I don't know why you're not getting the data if that's all you're asking for. It might just be if there's no compulsion to provide you with the information, it might just be that, you know, people, farmers, whoever, are just not willing to take the time to provide the data.
Okay. Yep, Stephen.
I can answer that from a data perspective, having done the migrant labour survey, where we actually used the official databases to try and work out how many European migrant workers were working in Scottish agriculture. There was no question about which countries they came from in any of the official documentation. So we then had to go back and survey them. But what we then found out was that some of the bigger producers that were traditionally not in the CAP, some of them weren't returning their census forms. And this bill tries to overcome that by giving the government some provisions to take actions against them. There is a challenge, and I think the convener points this out, is that agriculture is heavily surveyed. We know more about this sector probably than any other sector because of the Common Agricultural Policy payments. And I do always have concerns that we are dealing with commercial enterprises. Some of this is very sensitive business information, and we have to take cognizance of that when we're looking at statistical data and data sources. And not all of it should be open, and not all of it can be open. That's up to the individual to make a commercial decision whether or not they're going to use different tools that might be in the public domain, etc., in order to help them make decision making. And some of that might be provided by government or by research organisations who then have conditions attached to that data provision. So I think we have to be slightly careful. And on the disclosure, I mean, one of the conditions that we get access to data is always about disclosure, so that if we are actually getting data on farmers, that we are very, very careful, and we have to follow pretty strict procedures as to how we report that data. The biggest concern the government would probably have is some of the data they collect is done on a voluntary basis by farmers. So farmers volunteer to help the industry better understand the industry. And if suddenly there is seen as this is this data should be open and we should know who these people are, etc., then these farmers would potentially and legitimately just choose not to provide that data. So there are some instances that we have to take an awful lot of care with the data that we're talking about.
Very briefly.
I think this is for the ICO once again. And it's just a question about anonymised data, because I understand there are some constraints to prevent anonymised data revealing personal data. And in particular, that where the count of personal data in a category is 5 or less, is not disclosed. So I just wanted to get on the record. And I'm asking it because most farms will have less than 5 people on them. So anonymised data is not the magic bullet in many cases. And I just wanted to kind of get something on the record very briefly, Convener.
Yeah, you're absolutely correct. That's more to do with, statistical... I can't remember the actual word, not being a statistician, but that there are rules and regulations or understandings around the use of statistics. And certainly where you have small numbers in a small population, then you could effectively identify someone, even although it's just a figure you're using. So if you say if we think of disability, for example, if there's one person that's in a wheelchair in a very small population, then it's likely that people are going to know who that one person is, even although you don't mention their name. So yes, you do have to be careful, and you have to think about the statistics and think about how they might be perceived. There's also an issue in respect of anonymised data that some people think, excuse me, that if it's anonymised, then it's no longer personal data in their hands, and that's not necessarily the case. Once information has been published and it's anonymous, if I access the data from that side of the fence, then it's anonymous, absolutely, because I don't know who the individuals are, so long as statistical control, is the phrase I was looking for, have been applied. But on the other side of the fence, if it's me that actually has the data and I have the key to unlock that anonymised data and apply it to an individual, it's still personal data in my hands. It doesn't mean that I can't still use it and publish it. You can, but it's just the realisation that it is still personal data in your hands if you have the key to unlock it.
We are going to go on to the next question. I'm sorry, Stephen, we're just that's taken quite a long time to get there, and you probably get a chance to bring it in a minute. Mike Rumbles, Mike.
Thank you. Good morning, panel. I'm interested in making sure that the Scottish Government's policy memorandum is reflected in actually the bill that's before us. And I'll tell you where I am. The policy memorandum for the bill states that this bill is intended to legislate for changes made up to 2024. But the actual bill on section 3 says the Scottish ministers may by regulations modify the main cap legislation for the purpose of securing that the provisions of the legislation continue to operate in relation to Scotland for 1 or more years beyond 2020. And the reason I ask that is because the second part of this question is that the bill gives Scottish ministers powers to simplify or improve the operation of cap legislation. So my question really is, one person's modification of the main cap legislation can be somebody's improvement and major change. I think the policy, I'm certain the policy intention is to bring in a policy bill for 2024 to implement what the government's working on now for a future policy of this. The problem, as I see it, is the way this bill is written, after 2021, we may have a different government. And a new government coming in might look at these powers that are given in this bill and therefore not need to bring forward a policy bill for post-2024. Have you got any comments on that?
Yeah, you're right in a sense that a modification, one person's improvement could be another person's to somebody else's detriment. I think the terminology of improvement is in the general sense. And if going back to my work with Brian Pack on regulated or on red tape and regulation of farming, there was a number of instances within that where we identified simplification, but we were told that we couldn't have that because it was down to the EU rules and the EU wouldn't accept them. So I think it's in those minds that we're talking about that would actually it would make life easier for people on the ground. So I think that is the case. I can't speak for Scottish Government because I'm not part of it. I'm not party to their thought process on this. With regards to the 1 year thereafter kind of approach, I think that seems to be a logical approach given that they are proposing to take forward a new bill. I get your point that a new government in 2021 here may not need to or may not want to. So there's nothing to compel them to, which is obviously where your question is coming from, is that does this need to be time-bound and force the government to bring forward a bill in the future so that this does not work, this just doesn't roll over in perpetuity. And I can't answer that.
But do you think that we need a new bill for 2024 onwards about the policy that the government is working on at the moment?
If we don't, then we are still in this path dependency, not delivering potentially delivering the outcomes that society, government, the Parliament actually want, and probably farmers. We are stuck in a path-dependent agricultural policy. We have got an opportunity just now to break that path dependency by coming up with something slightly different. That's not to say that you're going to have lots of winners and lots of losers, but in terms of what we're actually, the outcomes we're achieving, and if we start focusing on those, and I think that's where government are looking. I can't, as I say, I'm not part of that futures group, so I can't comment on that, but I can see that we should potentially be looking for something new and afresh.
Thank you.
Does anyone else have a view on that? Okay, Mike, we'll move on then to the next question, which is Richard Love. Richard.
Yeah, and actually, thank you, Mr. Thompson. You actually basically saying what I believe. We've got to look at something new. So, in my previous question, which was not answered, I said there was a vacuum in the UK Government which spills over to the Scottish Government, who don't know what we should do. But we have to make up a plan, and we have to ensure that this plan suits everybody. And basically, so there is an opportunity, as you quite rightly say, to look at this and thing. So this bill gives Scottish ministers powers to modify the financial provision in the CAP legislation, for example, to ensure there is a legal basis for setting a maximum spend for agricultural support, to amend funds, how the funds are spent, who gets the funds, how much they get, what individual recipients get. So what are your views on the changes that need to be made? Do you have any concerns about what Scottish ministers may or may not do? And what would you recommend? I'd be very interested to hear your particular answer, Mr Thompson.
Looks like, Stephen, you're on. and I think it'd be helpful to bring other members of the panel in as well. So maybe everyone, Maureen, maybe not you, but at the other end of the table. Stephen, do you want to fire away?
The main question is, and sorry that was a long preamble, the main question is, whatever money is available, and we don't know yet, whatever money is available, how should it be spent? Should the jam be spread out more to people who in the past didn't get enough? Should we try and help everybody or help a section? I'd be interested to know the panel's views.
Stephen.
So, I said so, let me begin. It is a challenging question, and I think a lot of people have mulled over where we need to go in terms of agricultural policy. The provisions are quite strong in that it would allow pillar-to-pillar transfers. So it would allow ministers, I think it's in it through the affirmative process, to amend how much we transfer between Pillar 1 and Pillar 2. It would allow us to change the national ceiling, which is the budgetary constraints. As you rightly say, we don't know what that is, but I would also say that it's not just a UK government decision, that would be this Parliament's decision as well as to what the budgetary ceiling for agriculture would be. So the vacuum isn't just, we haven't made those decisions in this Parliament, never mind in UK Parliament, and one has to follow other. In terms of the priorities and should we change the way things are, I think we need to determine what the outcomes we're trying to achieve. We are trying to achieve lots of different things with agricultural policy. If you look at the principles of the CAP that were listed in I think in the explanatory note, you start thinking this is a really, really broad brush policy that we're dealing with. We're trying to deal with biodiversity, we're trying to deal with climate change, we're trying to deal with farm incomes and rural incomes. We're trying to achieve an awful lot with this. And unless we actually understand those outcomes better and actually understand the geography of these outcomes better, then you can't target your policy. Food is fundamental to agricultural policy. So at some point we need to support food production within this, but we also have to support the marginal areas where you've got very extensive food production or trees or whatever else we are doing with land management. So we have to, I think, take a step backward from this approach where it's a very sort of broad brush approach with these area-based payments that are non-targeted. They don't really reward. Well, what are they rewarding? They're rewarding minimal activity in some areas. So I think we need to look at that whole process again. Again, it comes back your point about those that didn't have, and this is the path dependency nature of agricultural policy, is that we always revert to, well, we don't want to have too many losers within this, but we quite often forget about the people that came in and didn't have in the first instance. Just an aside, I was giving evidence to the Just Transition Commission yesterday, who are also set up to provide advice to the Scottish Government. And I think they will be coming back with recommendations on agriculture and land management as to where policy might need to go in order to accelerate things towards a net zero emissions. So all of these objectives that government are trying to achieve we have to be careful as to how we target this support going forward, and it doesn't need to be the same for the whole of Scotland. We've been very critical of the EU for having a one-size-fits-all policy, which it isn't really. I mean, if you look at the agricultural policies across Europe, they're entirely different, but they've got the basis is the same under the framework. We need to be the same in Scotland. So what works in Lothian might not work in Shetland or the Western Isles, and we need to have that flexibility to actually have more place-based or regionalised understanding of policy.
Julie, do you want to...
Yes, I'd like to really reiterate what I said at the beginning. The reason I like the bill, I just think it's generally positive throughout. I think it's good that we are aiming to retain the EU laws where they're appropriate, but this bill allows refocusing on Scottish issues and allows us to have the flexibility to support the appropriate sectors in Scotland. Because it's linked to CAP payments, I think the payments can be, as Stephen described, paid in all sorts of different ways, but the main thing is that they have to drive beneficial change in Scotland. And I think those beneficial changes in Scotland may well differ from other parts of the UK. So the payments need to be based on productivity, so I'm a firm believer that food production is an essential aspect of the Scottish economy and really important for Scottish people to eat regional and national food. But we also have an opportunity for the first time, I believe, to combine food production with sustainable metrics. So, for example, food production that also addresses the carbon targets for 2045 of zero carbon. So we can do that in different sectors. We can do that in lowland food production, upland, hill and moorland and crofting. And there's different ways that that can be done. But in order to do that, we need to develop methods of measuring what sustainable production is and applying it to the right areas. And I think there's considerable work being done in that. One of the things that's really key to this is regional benchmarking, what we expect Scottish farming to be able to do. And that brings me back to the data question. The data is there, but we need to benchmark and use the data regionally to drive improvements and change. So for me, the CAP repayments would be to drive beneficial change and to hold the recipients to improved management of agricultural land. And I think you could argue that for other parts of the country, but there are specific issues in Scotland that I feel we need to address.
So basically, half the money for better outcomes and better food production, and to ensure and people then have the incentive. If you want a wee bit more, you need to do better.
Absolutely. And the incentives could be, for example, quality food production or animal welfare, or in the sustainability areas, environmental schemes that protect biodiversity and allow farming to go hand in hand. Lots of other examples on the environmental area, but the idea is that there should be targets for each person in different sectors to do better than they're currently doing for the whole of mankind, really.
One very specific point, but I do echo the comments of both the previous speakers. If the division of money across the UK comes down to the Barnett formula, that's not great for biodiversity because Scotland actually holds more populations of threatened species. It's really, really rich, really, really important. It's got much more to conserve, much more left. So it's crucial that Scotland gets sufficient funding to honour the value it can have for biodiversity in Scotland, which is punching way above the other countries of the UK.
I'm going to bring in you, Mike.
From the comments, both Stephen and Julie made clear that they think this is comprehensive legislation, that the policy could be changed using this. Which brings me to the point I want to make, is that giving this power to the minister, if you wish, whichever future minister post-2021 wants to have, he can bring forward new policy according to this authority, primary legislation, and all we can do in the committee, or in Parliament can do in the committee, is say yea or nay. We can't change anything that the Scottish Government brings forward. And I did ask earlier on whether you thought it was more appropriate post-2024 to have which what the Scottish Government tells us it wants, and I'm fully in support of that, a policy bill so that we can actually get our teeth into and improve for the better, I hope, as all government bills, whichever colour you are, can be improved. My worry is that they won't need, if we pass this bill in its current form, they won't need to bring forward a policy bill for primary legislation. What do you think?
Wants to reassure Mike. Stephen.
I think fundamentally, if they're going to make fundamental changes to the bill or the agricultural policy as it is, it would need to be in the form of a new bill. So if you want, no, they can make amendments to how much is going in from Pillar 1. Remember, we will still be bound by EU in all of this. So if we want to trade with the EU, and in the terms of the withdrawal agreement, whether we agree with it or not, we are still bound by ceilings and certain percentages that can be paid under different aspects. International trade will determine future agricultural policy needs as much as what we think it should have. So until we actually start getting down that route, we can't design a future agricultural policy. And our trade partners will be incredibly important in dictating or bounding what we can actually put into future bills. But your point, your point being is quite clear, is that I don't think I'm not a legal expert. Whether or not the basis of the legislation as it stands can change materially, whether they can do that within this and actually change the principles of the existing legislation enough that we would not recognise the agricultural policy. I don't think they can do that within this bill, i.e. I don't think they could get rid of basic payment. I don't think they could get rid of that. I'm not an expert. You guys know the law better than me. But if they did, I would suggest that if they were trying to do that, the government were trying to do that, then it should be as a bill. They can transfer, but we can transfer now. So under the EU rules, we can transfer. We have been able to transfer from Pillar 1 to Pillar 2. We chose to do that from 2007 onwards. We were one of the few that had voluntary transfers from Pillar 1 into Pillar 2. There was the compulsory EU ones. And that's where the measure is. If there's needing to be a top-up in Pillar 2, you would take some money out of Pillar 1 and top it up to have pilot schemes. That is my understanding of what's trying to be achieved.
But my understanding of the legislation, just reading it, is they could take all of Pillar 1 and put it into Pillar 2. At the moment, there's a modulated bit that goes across. Is that your understanding, or is that wrong?
Well, again, I keep saying I ain't a legal expert. Okay. But,
well, maybe that's why we'll need to
maybe that's what you need to
ask the Minister.
You need to maybe ask, and maybe you need to have a restriction on the amount that could be moved between pillars.
Okay. Julie, you wanted to come in, and then I'm going to go to Jeremy Green.
It is really just to reinforce. I do understand the question, but I personally just can't answer it because to me it's complexities in the wording which really needs to be looked at by lawyers. And I suppose what we're suggesting is that everything looks as if it's there. The timing and the issues of other policy bills, I think, are an issue for both government and for the lawyers. But I think the principles that we're talking about is to try to make sure that we do retain flexibility so that we can, over time, make adjustments as and when our farming systems change, which undoubtedly they will.
Jamie, you've got the next question.
Thank you, Convener. Good morning, panel. We could spend a lot of time discussing what the future of policy should look like. The panel will be aware that the current UK government has committed the existing levels of funding that currently exist under CAP until 2024. But obviously that's a financial amount. It's not necessarily a policy that goes behind it, because there is a divergence of policy across the four nations have produced separate papers and are looking very much at that. But I guess going back to what this bill is or isn't, does the panel think that the intention of the bill, therefore, is to simply allow Scottish ministers to continue to pay under the current scheme, to diverge from the current scheme, to simplify or improve in some way, or indeed, as other parts of the bill, such as sections 8 and 10, and indeed 7, go beyond that and allow us to make regulatory changes and also marketing standard changes, as well as changes to the financial method of paying farmers. Who wants to take a stab at that?
Stop. My understanding was that the UK government had only committed to 2022 because that was the life of the Parliament, so they cannot commit to 2024, as you just mentioned.
So that's depending on what happens in 2 weeks' time and who
Yes.
the government of the day is, of course. Yeah.
Yes. So we don't know until the next Parliament comes in when any commitments will be made. And as I mentioned previously, that then has to come through this Parliament. So the UK government may give Scottish Government money at the existing levels, but this Parliament would also have to allocate that to agriculture. Because my understanding from speaking to Treasury colleagues is that they wouldn't ring fence it. So potentially the Treasury would be coming in the Scottish allocation. The other provisions, I think, reading between the lines, understanding, speaking to policy colleagues, that this is meant to be able to deliver the existing policy as it is and make amendments that are beneficial to the farming population and perhaps society as we move towards improving biodiversity, improving climate change targets. And that is through this principle of the new policy development process. So it's quite clear within the bill that it's talking about enabling policy development, future policy development. It doesn't talk about wholesale change in policy at this moment in time. So within the bill, so if you add all the different parts of the bill up, it suggests that they're only interested in trialling new aspects towards a new bill or a new policy that would come forward in the future. With regards to the other parts of the bill, well, clearly European marketing, we're no longer going to be part of the collective, then we would want to be able to perhaps withdraw from that, which is where collectively the European Union markets, say for example lamb. There was an initiative where the European Union were trying to promote lamb consumption, not specifically Scottish lamb or British lamb or Spanish lamb, just lamb. And those kind of initiatives we would automatically probably not want to be part of, so you need to withdraw that bill. With regards to things like intervention and things, I think there needs to be scope to maintain that. The EU has that potential, America uses it potentially, America uses it in emergencies. We need to have that scope that we need to have storage and intervention in the markets in exceptional circumstances. A hard Brexit or a no-deal Brexit may be that exceptional circumstance where we might need it far quicker than we actually are thinking about.
Just a brief supplementary to that. Would it be your preference that if there were what we could consider not just simplifications or improvements, but substantial changes to the way in which we support farmers through a new system that's off the back of whatever policy the government of the day introduces, that should require quite a substantial piece of legislation that goes through this Parliament? Would that be your preference? Or would that be the best way to approach that, rather than use this bill to make those sweeping changes?
If it's substantially different, I would suggest that it needs pretty strong scrutiny, not just from this Parliament, but from stakeholders in the wider public and the people that are going to be affected by it. So yes, I would probably suggest that you would want, if there are substantial changes in the way that we support the land-based sector through agricultural policy, then I suggest that you would want parliamentary scrutiny on that.
You wanted to come in briefly.
Can I just ask Stephen to clarify something which you mentioned in that last answer, that in your understanding, Stephen, is that any monies coming from Westminster government to support agriculture in Scotland won't necessarily be ring-fenced, and that monies could be siphoned off to do other things once it arrives in Edinburgh here? Because if that is your understanding, that is a huge worry for me and for agriculture in general.
Those are understandings that I have, that we would be allocated the Scottish allocation, of which agriculture would just be one part of it, and then it would be for this Parliament to actually determine how that money was spent. That is my understanding. I might be wrong, I might be right, but that is one of the things that I've heard through various discussions at Westminster and up here.
Okay, thank you. Sorry, Jamie. Yeah.
I wanted to move away from payments and finance and talk about standards. And the reason I want to run it past the panel is because I don't know if anyone watched last week's session or read the official report, but I did ask a question to the panel on this. And the question was really asking that if there was a divergence of a direction of travel between the EU and DEFRA on matters of marketing standards or indeed regulatory standards, what the effect of this bill would have on the Scottish Government's ability to choose which. The answer I got was, if standards diverge because of decisions taken either at the European level or by DEFRA, and we have to decide which way to go, the bill will give us the flexibility to do it. We would look at whether the balance of advantage would be for us to retain alignment with England or with the EU. That was Dr. Burgess, who was on last week's panel. Can I ask the panel if they have any views on that, if that poses any benefits, advantages, or indeed any problems in terms of regulatory divergence?
Julie.
I think it would be beneficial to have the option for both, and again it allows a Scottish interpretation to compare it to the regulatory decisions made by the EU and the UK. So to me, again, it comes back to Scotland. The regulations might change because of our different farming systems, perhaps because of our continuing focus on sustainable productivity, for example. Animal welfare is also another really important one where we would need to be able to compare what the EU decide to do and what the UK does. So I think this bill covers that with its lists of agricultural activities and areas that are defined by the bill.
Thank you.
Stephen, do you want to?
I mean, one of the concerns I've always had when we were taking the EU AQUIS and putting it into UK legislation was actually if we're trading with the European Union going forward, we will need to comply with their rules and regulations anyway. So we can't actually be that divergent from them. So we need to be able to have the flexibility to deal with their changes and their regulations. Otherwise, we might not be able to sell product into them. And also we need to have the flexibility to relabel things as Scottish or British or things that are slightly different in terms of labelling standards. The whole thing about the frameworks and the regulations that surround agriculture, because we don't just talk about agricultural policies being payments, remember. There's a whole series of legislation surrounding traceability, pesticides. All of these standards need to be set. And I would say these are the standards that we need to have commonality across the UK, of which we're going to have to probably have quite a lot of similarity with the EU on. And I think the bill allows that. When I read the bill at first, I was slightly confused as to the wording of it, but then I came to understand what the Scottish Government officials were meaning in terms of their ability to adapt with regards to what Westminster chooses to do.
Thank you. The next questions are from Stuart. Stuart.
I think I and my colleagues are now moving to talk about the collection and processing of data part, and we've covered quite a bit of that en route. So the main one I'd like to maybe just is probably for the Information Commissioner's Office, just simply what the legal need is for us to update in this context how we acquire, process and use data.
Where do I begin? A bit like how Stephen felt. So I think really if I just try to talk through the basics of data protection and to think about the processing of personal information. And remember, processing is anything you can do with a piece of personal data. It's set out in this piece of legislation, which essentially simply mirrors what's already set out in both GDPR and the Data Protection Act 2018. So you have 6 data protection principles, That is your framework, essentially, for the lawful processing of personal information. And you have to work within those 6 data protection principles. The first 2, from my perspective, are the most important because they provide the foundation for any processing of personal information. You could get the rest right, but if you don't get the first 2 right, then you're literally building on sand.
Come in. Fascinating as that is, and it's necessary we understand that, I've got my question is maybe a bit narrower than the generality. It's simply what in this area, why are we doing anything with data in relation to this relatively narrow bill? You know, what's driving that rather than the generality?
I think inferring from what you're saying is that the current data protection legislation would allow you to do this information sharing anyway. Why is it on the bill? Is that essentially your question? It's on the bill for the sake of clarity and to ensure that there's an unambiguous legal gateway to allow for this information sharing. You could, I mean, currently when I was looking at the SPICE briefing on it, alternatives were thought about. You could rely on the agriculture bill that's going through Westminster, but what that does, you're then looking at trying to fit your activity, the processing activity, into something that's not specific for that particular activity necessarily. And what you're then trying to do is say, well, if we think very broad terms, but what this bill allows you to do, it breaks it down into very specific terms. It sets out the purposes, which is your second principle. It sets out the lawful processing, which is your first principle. And it sets out the fairness and transparency simply by being here and the regulations that have to follow in relation to the information.
So therefore, and one of my colleagues will talk a bit more about the purposes section at section 16 in the bill, so I'm not trying to open that up at this stage. So really, it is simply making sure that in a bill that's about agriculture, we are using the existing powers and stating them in relation to agriculture. And that's really the purpose, rather than creating any new powers whatsoever.
Indeed, absolutely.
That's fine. Thank you,
Stuart. Angus.
Thanks, Convener, and good morning to the panel. We've discussed collection of data earlier. However, I'm keen to hear the panel's views and reflections on the way in which Scotland collects and uses agricultural data, but also what types of data do your organisations rely on, which is currently collected by the Scottish Government?
Who'd like to go off with that? Stephen, do you want to start?
All of it. Well, our research, which of course is significantly funded by the Scottish Government, is heavily uses some of the data sets. So in particularly the Farm Business Survey, which is the financial data that's gathered, that's currently part of an EU regulation. So we utilise that quite heavily to understand the financial performance of agriculture. We utilise things like the June Agricultural Census, the December Agricultural Survey. There are colleagues in other institutes that heavily utilise the IACS, which is the control system, the application system data, which allows us to look at field level or what's happening in farms at much more nuanced levels. We utilise things like the CTS, which is the cattle tracing systems data. There's the Scott EID data sets. We use a wide gambit of data to help try and portray a picture of agriculture in Scotland and whether or not policy interventions are actually having effect, the desired effect or otherwise. And then there's a whole host of other biodiversity data sets that are perhaps more in the public domain but aren't really covered in this, that aren't really part of this data collection exercise that the Scottish Government are talking about. But under the guise of this bill, pretty much all of these data sets will be used for research purposes where appropriate.
Julie, you want to
I would just like to, I won't reiterate, but I agree with all the data types that Stephen has described. From Moorden's point of view, we work mainly on animal health, so we're interested in farm productivity levels, which allow benchmarking of different quartiles of production. Animal health, welfare data through the Food Standards Scotland, disease data, animal movements, and then things like soil types which are held, and we also use the cattle movements and some data held by organisations like Quality Meat Scotland, which of course receive funding from the Scottish Government. And again, I would just like to emphasise that I think the data types that will be collected in future will change in Scotland because we're using big data much more. It's evolving incredibly rapidly, and the data types that will link to CAP and will link directly to the Scottish Government will differ in Scotland from other parts of the UK. So really important. I understand better now why the sections are there, and I think the reason some of the data sections are there is that there will be different types of data in our systems going forward.
Ellen, do you want to add anything?
Yeah, so the biodiversity sector uses lots and lots of data sets from agricultural information. So in particular, the IX field boundaries are really critical, often difficult to get hold of, but having things spatially is really relevant, really important for us. All the biodiversity data sets that I think we contribute the other way. We actually might be involved in collecting many of the biodiversity data sets that government will then rely on to understand responses to particular prescriptions and interventions. It's particularly important to us that we understand exactly what intervention has happened so we can look at the impact and the value of the scheme, whether it's appropriately targeted, that kind of thing.
Okay, and would you say that your organisations are in a position of collecting or processing the agricultural data on behalf of the Scottish Government?
Our colleagues under contract collect the Farm Business Survey, so the government don't go out into the field and deal with the farmers on that one. We collect that data. There are likely other instances where the government contract in people to do that. So on one hand, part of our organisation know the identity of individuals, but as a researcher, I don't get, that data goes to the government, they anonymise it, and then I get those anonymous data sets. So there's a real complexity in terms of data understanding. And data linkage, we haven't mentioned data linkage, but one of the powers of research is being able to link different data sets together to enhance our understanding of these things. And that under the GDPR, we're allowed to do it. It's a slightly more complex way of doing things just now. We just have to be robust and explicit in how we're doing these things. But yes, there'll be people collecting data for the government on various different ways. I couldn't probably list them all just now for you, but I could probably ask our colleagues what data sets we collect that are considered governmental data sets.
Okay, that'd be helpful. Anyone else?
Yeah, so the biodiversity sector clearly relies on lots of volunteer data collectors in all walks of life, for all taxonomic groups, in all locations of Scotland. They particularly culminates in the State of Nature report, which is the flagship report that the Scottish Government has an interest in for reporting on the declines, the impacts of the industry that we're talking about today. But really, from my perspective, I guess my own organisation is RSPB. We collect lots of long-term monitoring schemes on birds in particular. But the wider Scottish Biodiversity Information Forum community will be collecting all sorts of taxonomic information and providing some of the expertise to verify data sets. So we're instrumental in some of the verification processes that support the biodiversity side of things.
Okay, thank you.
We collect a lot of survey data through contract research, either through the strategic research programme or contract research. Generally, that information does not go to the Scottish Government. We control it, we hold it, we analyse it, we delete it when we're finished with it. So whilst the government pay us to do those things, it's not an official data set as we're talking about in this bill. So these are pretty explicit data sets that the government need to help us to best understand agriculture.
Okay, thank you.
Emma, I think you've got the next questions.
Thank you, Convener. Stephen, you mentioned earlier about collecting lots of data in agriculture, and obviously there's really important reasons why we do that with agri-supply chains, health and well-being of plants, animals, people, and just issues around soil, there's biodiversity, climate change. There's a whole section with multiple lists here of what it is that we're looking at when we're trying to collect data. And I won't read them all out right now as well under section 16. But are there any, in this section, it says that, I mean, there's loads of reasons why we're connecting, which I've said, but do you think there's any others that are missing, or do you think there might be any problems with that the bill causes for collecting any data?
Who'd like to go off on that? Well,
I think the lists are pretty inclusive from an agricultural point of view. I'll leave the issues about biodiversity to Ellen. So to me, the bill makes good provision for data to be collected and in fact clarifies many of the issues. Some of the descriptors of animals, etc., are quite broad, so there's lots of things that you could fit into that definition. Otherwise, the list would be almost incredibly long. So to me, the broad definitions cover the types of data sets that we would wish to use.
Right. I think my issue would be where if simplification drives you to collect less data, where you can less well effectively ascertain impact and value. So we must continue to collect sufficient information around impact and value so you can really target and understand the impact of the system.
And one of the issues is around climatic risks and risks from disease and pollution. So obviously, this is really important that data is collected and then managed.
All sectors can make a contribution to that. So again, the offering from the citizen science side of things is collecting information over and above what the monitoring schemes actually currently make provision for, and that can detect early arrivals. It can help with identifying particular diseases and understanding the ecology of those. So there's a whole thing in support of data collection that makes it possible to extend the evidence base and again to verify and to have early warning of invasive species.
Mm-hmm.
Stephen, do you want to add anything?
No, I was going to say that the bit that is not explicit, but then I found it was on the social dimension of it, i.e. employment and people engaged in it, because it's important that we understand the challenges, but it actually does talk about the health and welfare of people or animals. So there is a social dynamic in it.
Okay, thanks.
Colin, yours are the next questions. Oh, no, sorry, Stuart corrected me. He did actually, and I said I'd bring him in, Stuart.
I'm obliged, Convener. Sorry, Colin. I just wanted specifically to ask in relation to 16.4G. Don't worry, I'll tell you what it is. It says, monitoring and analysing markets connect with the agri-food supply chains or agricultural activities. And I'm interested in the supply chain because it is quite clear in the definitions that essentially the supply chain is everything from the cauliflower in the ground to it appearing on my plate. And it's pretty well acknowledged that supermarkets have got a quasi or perhaps actual monopoly power in relation to farmers. And I just wonder whether that is somewhere that we might be able to gather data to offset, I think, the acknowledged weaknesses of the grocery code adjudicator, which has as part of their brief to ensure that direct suppliers are treated fairly. That's part of what they have. And I think there's a widespread view that they're not. Is that your understanding of what that would enable to happen? And then as a secondary part of that, are you aware of any Scottish Government activity in this area at the moment? Because clearly it crosses the legislative boundary between Westminster and Scotland.
Everyone, I forgot to say at the beginning, if everyone looks away at the same time, then I have to nominate somebody. And you all did look away, but Stephen luckily put his hand up because he was going to get nominated anyway. Stephen, would you like to answer that question?
So yes, so some of this will be about the collection of market data, price data that farmers are getting in various different stages of that process. I understand that it will also collect data perhaps from abattoirs in terms of throughput, those kind of things. Whether it has always been intended, I mean, when the UK Agricultural Bill came forward, I kind of did think, wow, how are they going to achieve going through the entire food chain from, as you say, cauliflower to plate? That could be a real challenge to get that level of data. But in the UK bill, it talked about fairness across the supply chain and requiring data in order to determine that. That then puts quite a big burden on data, or a new data exercise that we currently don't have. There is the Kantar World Panel, there are other data sets, Dunnhumby, etc., where we understand the prices at the retail end. What we don't really know probably is what the price differentials between the processor and the retailers are. And HDB did collect some things where you could calculate farmer to retailer spread, so you could understand how much differential there was between the consumer price and the farmer price. And then obviously the food processing bit was the 50%-ish in between. So there's, I don't really know what the exact purpose of this is, but it would be useful for us to better understand where the margins are. I know there are very tight margins in things like the abattoir sector, the food processing sectors. There are very tight margins, but that data isn't publicly available.
You're not disagreeing, but not necessarily agreeing, with the proposition that where it says analysing markets connected with agricultural, agri-food supply chains, this could place a duty, a power to collect data from supermarkets, and when taken with Section 13, which is about requirements to provide information, require the supermarkets to provide that. I'm getting a nodding head, so I think... I mean,
that's what it reads like. Yeah. As again, I can't, as I'm not in the government, I can't tell you what their thought process is behind this, but I would also say then you might have to collect data from distillers, millers, all of these kind of things, if that's essentially.
I only deal with what's in the bill. Yeah. I don't actually care what the government thinks.
Yeah.
I only care what they write in the bill.
I'm afraid Stuart's questions prompted a whole lot more, so I'm going to ask them first. So you've got a bit of a pause. Emma, followed by Maureen.
It's just a wee sup, actually, about that, because it's really important that we look at these markets, because we do have challenges with the sheep sector, with sheep in Scotland goes to other places because Scottish folk don't eat sheep meat. And then there's also the dairy sector as well, so the volatility in the milk market that means that we've got a supply chain that might be interrupted or not. So would that be part of this analysing of markets so that we can look at where our supply chain is broken or fails to support the producers rather than the processors, and then the big giant Tesco's, etc.
Julie, do you want to come in briefly?
Just to say again, I think those are questions for legal advisors, and I can see that companies or organisations that claim commercial interest just cannot be enforced to provide information unless they are in direct receipt of government funding in some way. So although I agree with the principle, it would be nice to have that and very important for the future of all of our different food chains, I just can't see that this bill will allow that to happen. But it's a legal question, I feel.
I'm going to bring in Maureen and then I'll come to you, Stephen. Sorry, Maureen.
Yeah, given what the answers have been to this question and what you said earlier, Julie, about the needs of biodiversity and climate change, is it a case that the supermarkets are going to have to absolutely change their view of what's provided by the farmers and not be so prescriptive about, you know, the fat content of beef or whatever in going forward?
I mean, I think in an ideal position, it's really good if everyone down the food chain has discussions around these issues, but the legalities of data protection, companies having to produce data, I really can't see that this bill will allow that to happen. But I agree with you in principle, it would be very nice indeed if we could.
I'm going to leave that there and move on to Colin, if I may.
Thank you very much, Convener. I think we've touched on this quite a bit, but just for the benefit of any doubt, that the policy memorandum states that data collected is used to analyse economic output and performance, the effectiveness of policies, and to help Scotland provide information on the sustainable development goals. Are we currently collecting the right data for those purposes. And given the change, the political change, the climate change and the pressures under rural business in the future, is there additional data that we'll have to collect in the future? And I suppose, does the bill make sure that that's allowed?
Who'd like to go on that? Ellen?
So it probably doesn't collect sufficient data, I would say. Exactly what you'd need to do to remedy that would need an assessment. So clearly climate change and the biodiversity crises are coming up here with us, and we need to really make sure that the agricultural policy and the bill supports our ability to respond to those challenges. So I think there's much to do.
Stands at the moment, we'll be able to collect that data that will be required in the future. There won't be any restrictions as a result of this bill.
It may permit the collection, but I think it might be more about the design and about the efficacy and the purpose with which you're using the data. So I think it needs to be some rigorous scientific design involved to make sure that's the case. It really does reveal the impacts that are being had.
Stephen.
Can I just come back? At some stage we have to work out that there is a data burden here, and the data burden can't be excessive to people. You know, it's got to be. This is why we don't ask for everything, or government doesn't ask for everything, is because otherwise these farmers would just simply be doing paperwork all the time, and some of them already would think that. Can I just make one point about supermarkets, because they get a hard time. Some of the people that are on aligned contracts with these supermarkets are jumping through incredible hoops in order to get premiums, and they're already, so the supermarkets are driving private delivery of these public goods or environmental benefits.
Just in terms of future data, I hope it doesn't happen, but changes in trade of animals, plants and food products may indeed pose additional risks to all parts of the UK, including Scotland. So I think there's always the need that we have to be prepared at the very last minute to start data collection where there might be, for example, an incursion of an exotic disease or even a new and emerging disease, because, you know, the genetic mutations that happen mean that you can get new organisms appearing. So there always has to be a provision for the unknown unknowns.
For the unknowns.
I think it does, because the list is not, it's broad enough to include almost everything I could think of without being too prescriptive, so to me it does.
Comment on
Sorry,
that,
Maureen.
just to say that what you have in section 16 are your very broad purposes, and under data protection legislation, the second data protection principle talks about specified lawful purposes. But in terms of further processing, there is absolutely no problem in terms of data protection as long as the further processing is of a purpose that is not incompatible with the original purpose. And some of these, as I say, are so broad that I could well see them being, you know, utilised for further purposes that are in alignment with these purposes. And from a data protection perspective, that would be fine.
Just before we go on to the next question, Emma, I think you wanted to just follow up a question that you'd said earlier.
Yeah, I just wanted to clarify when I said that Scottish folk, I want to say we don't eat enough sheep meat, right? It's let's all eat more, support our local farmers. That's what I was wanting to say. Thanks.
I felt sure that's what you meant in the first place. The next question is from Peter. Peter.
Yeah, I mean, the Scottish Government state that there will be no additional requirements placed on farmers and crofters in order to collect additional data. Now, that will be very welcome. As Stephen rightly mentioned, you know, farmers are out there to produce food. They don't want to be sitting in offices all day collecting data. But the Scottish Government are exploring, they say, new technologies such as satellite mapping, for instance. So my question really is, how useful is satellite mapping? Is it available now? Is it used now? And what other new technologies do the panel feel that could come down the road that will help to collect this data without an additional burden on the producers at the sharp end?
Ellen.
It's a huge opportunity, so everything from drone imagery through to artificial intelligence will really help, but it's still got to be tailored. There's no substitute for actually checking on the ground what's actually happening and training your computer to understand what it's seeing, what it's interpreting. But I think there's huge opportunity, but it comes back to design and designing why you're collecting it, what you're going to get from it, so you can really take advantage of those technologies. But there's huge opportunity in this space.
Okay. Julie.
Yes, just agree. I mean, again, the opportunities for easy data collection, I think, are numerous. Good examples are in terms of smart farming and some of the targeted pesticide applications on crops, sensors on animals which will measure their well-being, how they're moving around, temperatures and onset of disease. So, you know, I think, again, the bill has to be able to cope with new technologies coming in that hopefully will reduce the burden on the farmers per se in terms of data collection, but while still ensuring the data is collected.
Stephen.
Yeah, there's two elements that are being discussed here. One is, I would say, private data, i.e. the farmer buys a piece of tech that is data, and that's private data, and that generally won't make its way into the public domain, whether we like it or not, or as researchers, we may actually, through collaborations, get access to that. With regards to Peter's question on satellite imagery, yes, there is scope that you might not have to declare your June census form or your IACS form because they can tell what your crops are growing on the ground. That would be a saving of time and effort. On bovine EID, I know that there's been a lot of discussions with Scott EID as to whether or not a new tagging system could replicate or get rid of the passports. That is another data burden on farmers. So there are lots of opportunities where the regulatory data burden could be removed through tech. And I know that the Scottish Government are trying to do that. If you look at your forms, your June census form, the December survey, those forms they're trying to minimise the amount of effort that has to go into filling those forms in. So they are looking at all opportunities as far as I understand.
I think that's all the questions. I've just got one question. I'm sort of half made to feel better by that last answer, but I mean, I know farmers across Scotland always look forward to getting their census forms every time they come out, and they get asked a list of questions, many of which could be self-populated by the information that the Scottish Government have already, whether it's numbers of stock on the holding, because all of that is already recorded, as is the cropping, as is the age of the grass from the last agricultural census form that was filled out. Some farmers will get more than one agricultural census form because some fields form different holdings to the other. Do you think there's any chance that this data provision within the bill is going to make it easier and farmers aren't going to have a book and they'll see the government self-populating some of the answers themselves from the information they already hold? I don't know who'd like to go with that, but that would be a nice Christmas present for farmers, Stephen, if you could tell them that was the case.
You've just told them that. No,
I'm asking if you think that's going to be the case.
All right. I think they have been trying to do that. I mean, you're quite right, is that it's because we're collecting data for official purposes at business level, but we still collect at holding level for other purposes. And it's these cross purposes which is leading to the confusion. So quite often I hear there's 54,000 farmers in Scotland. No, there's 54,000 holdings, which are totally different from farmers as a business unit. So, you know, those are the issues. And it is a technical difficulty, but I know that they're trying to use they have used the CTS data, that's the cattle tracing system data, to populate your cattle data where they've got it. Whether they're using the sheep inventory, probably not, because it's a different point of the year. They need to understand lambs, number of lambs on the ground. So there are challenges in terms of it. So I understand the frustrations, but the data is useful.
Does anyone else want to comment? Or Ellen?
Take a bill to do this. You should continue to be improving how you hold and store and collect data, and there's just endless opportunity, and it'd be great fun to do it. So I think, wouldn't it be wonderful if we can actually continually improve every single aspect of this? It should be perennial and should get more and more wonderful. There's so much public good coming from this sector. I think it really merits investment in the monitoring and in the service design side of things. So I think if the bill can make provision for that, proportion of the funds available to go into that side, it would help everybody.
Okay. Julie.
I think my final view would be that, you know, because of the lack of time for data issues, it's really important that we focus on the most important data and then use that data in the most important and beneficial ways to drive, you know, the country to the outputs that we want, which are multiple. But if we combine the data sets that we have and we get even better data sets in the future, you know, I think we've got a great opportunity for science and farming and the countryside to come together and really produce excellent outputs.
Okay. Oh, there's a positive note maybe to end this session on. I'd like to thank all of the panel for coming in this morning. Your evidence has been extremely helpful. And I'm now going to suspend the meeting for 5 minutes to allow the panel to depart. 5 minutes. Okay, we'll move back into a session and move on to agenda item 2, which is consideration of a public petition PE 01616. Now, before we do, I am going to make a declaration of interest in that I have an interest in a wild salmon fishery, and although that does not relate to this petition directly, some people may feel there's a link. And this is the petition is to consider this petition, sorry, sorry, my mistake, it is P01715 by Mark Carter on behalf of Marine Concern on closed containment of salmon farms in Scotland. And the committee is invited to consider what it wishes to do with this petition. I just remind the committee that we did consider this as part of our research into the aquaculture industry, but I wonder if there are any comments from people, from committee members. Yes, John Finney.
Thank you, Convener. I'd like to acknowledge the representations we've received in respect of this item. I know that when the Public Petitions Committee considered it, the Scottish Government response referred to ongoing work by the Scottish Aquaculture Innovation Centre. And I would like to hear from them about this particular, their views on this, and indeed from the Producers Association, and I'm sure interested parties listening in could contribute as well. But I think it's important that we keep the petition open in the first instance, but seek these, the views of these organisations.
Thank you, John. Richard Lyle.
Yes, I would certainly agree with the points made by John Finney. I've actually had the benefit of being on both committees, the ECCLR, Environmental Climate Change Land Reform Committee, and also this committee. Whilst I don't see any evidence for this petition, I'm quite happy to write and await further discussion.
Thank you. Jamie Green, followed by Stuart Stevenson.
Thank you, Convener. Can I thank the petitioner for keeping this important issue on the table of the committee? I think it's fair to say, though, that the committee has done a substantial amount of work on this issue and put a lot of time and effort into the aquaculture report. However, it was a year ago. I know we took a recent update from the Cabinet Secretary earlier in November. I think this petition, whilst people and individuals may have views on the premise of it and agree and disagree with the premise of it, it's been a very helpful way of ensuring that the matter is still in the public domain, and that the validity of the report that the committee did still has substance and importance. So I would suggest that we engage with any stakeholders who have a view on the content of the petition and would like to comment on it. It'd be very interesting to hear the responses and indeed the government's view on it in due course, if that was appropriate, and take a view from there, again, parking aside any individual views on the matter. And I think that would be helpful and respectful to the petitioner.
Stuart, followed by Emma.
I support what John Finney's proposed as a way forward for the committee. Looking at the wording that's in front of us, however, it will take a very powerful argument to persuade me to accept this petition. And let me explain why. It says solely utilises a closed containment method. I think that's a fundamental problem which I have difficulty with. But even more, it says with full water filtering in Scottish waters. Now, the meaning of that's slightly ambiguous, but it appears to suggest that the salmon fishing industry must remain offshore. Whereas I know, for example, there are trout farms that are onshore and, you know, operate in a perfectly well. And I wouldn't want the petition to make it difficult to have onshore farms if that's the appropriate solution to certain problems. So I've got some difficulties with the wording of the petition, which, as I say, but I think we should be informed by what's going on, and the Scottish Aquaculture Innovation Centre's work is a clear and obvious place from which we should solicit information before coming to a conclusion.
Okay, thank you. Emma, I think
Thank you, Convener. Like my colleague, Mr. Lyle, I was on Environment Committee and Rural Committee a while back, but I wasn't on the committees when the salmon inquiry was was conducted. So I would like to see further information, and I'm interested in what the Scottish Aquaculture Innovation Centre would have to say, and further evidence regarding this.
Angus, I think you're next.
Okay, thanks, Convener. I've also got the benefit of being on the two committees now. However, previously I was Deputy Convener of the Public Petitions Committee, so I've followed this petition since it came in front of Parliament. I think it's clear that the jury's still out on whether or not the technology exists to make closed containment economically viable. So I would support John Finney's suggested course of action seeking the views of the SAIC, but I think we should also seek the views of the SPSO with regard to the commercial viability of the closed containment. Sorry, not the SPSO, the SSPO.
Okay, John, I know you want to come back. Can I hear from the other committees members first? Mike, if you'd like to.
Yeah, I thought, and I think the petition is quite clear, whether you agree with it or not. It is quite clear, so I'm somewhat confused by, I wasn't going to say much, but I was confused by Stuart's contribution, which I think has just muddied the waters for me. So I think it would be helpful to find out more information about this, and I think we should do that.
Colin, I think you're next.
Yeah, I agree with the proposal from John. When we carried out our inquiry, we did take a lot of evidence from people who were very strongly in support of closed containment systems, but there was also those who gave evidence who questioned the current viability. But viability is something that obviously changes over time, so it would be good to look at this issue and to see whether there has been any change since we carried out our report and inquiry.
Peter, and then I'm going to go to the Deputy Convener Maureen. Peter.
Well, I basically agree with John's suggestions. Well, I think we should look at the most recent evidence on closed containment. I think that's right and proper to do so. I also have serious doubts as to whether it's that the technology is up and running to the extent that it could be viable going forward. But let's look at the evidence, and let's not close our minds. Let's have a look and see. I'm quite content to do that and leave the petition open at this time.
Okay, thank you, Maureen.
Yes, I seem to agree with the majority that we should get some more information before we decide how to proceed with this petition.
Thank you. John, did you want to come back?
Just as a point of clarification, Convener, and thank you for letting me back in, I didn't express a view one way or another on the merits of the petition. As it happens, I'm not persuaded, but I want to have an open mind, as Peter and others have suggested, and the way to address that is to get the most up-to-date evidence and make a decision thereafter. So,
okay. Thank you, everyone. I think everyone now has had a chance to say something, so maybe if I could just sum it up at the end, just by adding before I do a wee comment, is that having done a very detailed report as a committee into the aquaculture industry, which was, I think, well received, I think it's important that we continue to look at it. And certainly, I was looking at figures produced by the Scottish Government of mortalities in fish farms. And as you know, this is produced 1 month in arrears. But if you go to the website, you can only do it up to the end of September, so it's not quite as up to date as I had. But I looked, there were 747 cases of mortality across fish farms in Scotland. And of those 747 cases of mortality, 108 of them never reported how many fish were actually lost, which was quite interesting. And there was one farm in particular, a producer, that had the majority of those 108 incidents. But there were 3.5 million fish lost to the industry during that period, which is quite a large figure in my opinion, which is why I would support the committee wanting to look at this further to see if there's ways that the industry can look at what they're doing and to help the industry develop a way forward. So on the basis that we all seem to be agreed, I think what we're suggesting is that we write to the Scottish Aquaculture and Innovation Centre to seek further information on how they are supporting innovation in this field and what's going on, and also to write to the Scottish Salmon Producers Organisation asking them to provide details of the research on closed containment that is being undertaken by the industry. Jamie.
Would it be appropriate as part of that to write to the relevant government minister responsible for this, or a government agency instead?
I think the appropriate thing at this stage is to, once we have that information, decide what we want to do next in relation to that, because that information that we get from those two organisations may help chart a path forward. But if we're happy, yes, sorry, Mike, yeah.
Just about due process, I don't know if Mr. Carter, the petitioners, would be listening into this or not, but surely for writing, should we not just let him know what we're doing?
Of course, the petitioner will be kept informed of exactly what the committee, the committee's doing. So if we're happy, that's what I propose to do. Are we all agreed?
Agreed.
We are agreed. Thank you very much. And the committee will now move into private session.